And it's your boy Bandele, ill in the building, Baragani,
Yeah.
Islam,
So
Salam, Hetepu,
today,
Rahubat.
today we gonna cover some topics. We're gonna talk about traffic law, and we're gonna talk about jurisdiction, and give y'all a concept of understanding how to look at jurisdiction, and give you some of the basics, the 101s. We're not gonna hit you with the complex, sophisticated things on this today. We're gonna build this up. But first, I want to talk about go to Amazon, purchase the book How to Stop Child Support by your boy King L Bay. Me live in the flesh right now. Go get the book, a copy on Amazon, and get your book on how to stop child support. I also got the
Sir,
Moorish blueprint. You know the book. I got it. It's going through some revision. It's been up for a while, but that book will be coming soon. So, all right, Chief.
all right, and I'm gonna pull up. I'm gonna pull up the other one, and then you guys can always, you know me, got all my books. Check them out. Check out all my books are here on Amazon as well. Um, I got a few of them, so just check them out. Depending on what you need, we got the treaty books 1 and 2. And then the latest book is the Melanated, Navigating Melanated Love and Relationships in the Modern Era. So you guys trying to understand, looking for love in all the wrong places. Well, check this book out, right? So, um, with that being said, we gonna get into this. We gonna get into this. I'm just trying to see. I feel like I'm lagging, and I don't know why I'm lagging like this, but I ain't gonna trip. So let's get into this, man. Like today, like we said, we get into jurisdiction. Uh, it's a topic that is, you know, it's a wide. Like me and my brother was saying, it's a very large topic. It has very intricate pieces to it. It's not something like very simple, right? So we trying to break it down so that people can understand it at certain levels, right? Because there are like more intricate levels to jurisdiction. Um, but most people, when they're dealing with basic stuff that's going on, like traffic, criminal, things like that, civil, like these are the basic jurisdictions that most people are dealing with, right? So what I'm gonna do is we're gonna show you guys how to deal with jurisdiction in the courtroom, like when you're just dealing with your basic stuff, right? So we talk about jurisdiction, we can't say, oh, what's your jurisdiction? What jurisdiction is this? And like we thinking it's just one type of jurisdiction. It's like countless jurisdictions, right? Countless views on jurisdiction. So this is right here. We're going to talk about like the types of law and jurisdiction. Um, so I say once you have become familiar with the legal topic from reading an overview of it on the legal encyclopedia, the treaties, or other secondary source, you will likely want to explore it further, right? So it's saying although the term law is used generically, there are three major categories of law that they're talking about. Each of which is described more fully in the following subsections of this research methodology. So we got case law or common law. This is created by a judicial body. Example is like a Fourth Circuit Court of Appeals or like the Virginia Supreme Court. Okay, so a lot of people when we talk about case law, it really is common law as well. a lot of us, a lot of brothers talking about common law, but this is really what common law is. Um, did you want to say anything about that?
Um, Basically, when we look at s- looking at the common law, it it we talk about several jurisdictions, but I'll let you go ahead for a second.
Okay, I had to stop. What? Okay, you there?
Yeah, yeah, my daughter. So when we talk about case law and with common law, you got customary law that falls in the category, an element of common law, because the culture and custom of that nation would be the common law that everybody know. Like if you're dealing with a Muslim nation, that would be the common law, that law that everybody is a Muslim nation, or based on their particular custom that will fall in, and then based on the contracts, right, that they're utilizing based on their custom, that can, further deal in the common law of the parties in relationship to what they got going on. So, when we talk about jurisdiction, it's a vast topic. But we're giving you some simple points and simple overviews, that stuff that y'all probably need to understand simplistically without hitting you with all of this sophisticated stuff. I've been doing this for a long time, over about 14 years, and my litigation paralysis, is through the roof. So I didn't litigate it a lot, pills and stuff like that. So that's just one element of discussion with the common law that we can talk about dealing with, the common law or case law.
Okay. So y'all, so y'all understand, like when they talk, when you hear the term common law, that can really be referred to as case law, because a lot of times you don't even hear common law used in court anymore. They don't really use common law. They try to tell us that um, we're not under common law. They tell us that we're under statutory law, which is the next definition. And statutory law is saying that it's created by a legislative body, such as your U.S. Congress, or it could be your state. For example, this is the state of Maryland General Assembly. So when you've got um, legislative bodies that get together and pass legislation, that is what they consider statutory law. And really the majority of the law that we're being adjudicated under is under statutory law. Would you agree with that?
Yeah, yeah. And how did this work is that each you got the separation of power doctrine. I'm not gonna try to complicate it. So um the General Assembly is birthed out of Congress. It's within the confines of the congressional jurisdiction. So it's an agency of a sort of Congress within the state. So and it falls on that side of that banner dealing with the separation of powers. It's a legislative body that's birthed out of Congress within the state boundaries. And you have to understand that because each branch has its own like administrative agencies in which um, operate in each jurisdiction. So, like the executive branch, it has its branches and administrative bodies that it regulates and control. So you got Congress, which has the USCs, United States codes. Then you have the executive branch that deal in CFRs. Then you have the judicial branch that deal in the rules of procedures. They create all the procedures. So each one, particular to its jurisdiction, they have the right to rule on their subject matter jurisdiction because they the ones who created those jurisdictions. So that's how that works. That's why when you're dealing with rules of procedure, the Supreme Court, they can rule on that because they created those rules. They put in those construction of those rules so you'll understand in the CFRs how the legislative body and as far as Congress and which is Article 1, and the executive branch, which is Article 2, how do they work together? They adopt each other's rules. So they are put it into a legislative where you won't really understand how they are meshing together, but they use through their adoption of each other's rules. Now you intertwining with both jurisdictions at the same time, and a lot of us is not familiar with that. So I just break that down, and excuse me, we'll do a show on that, breaking that stuff down, showing you as we build up this platform.
Right. So check this. So he did mention the administrative laws. So that kind of takes us into the next um, jurisdiction, which is regulatory law. And that one is not. I don't think this one is heard as often in practice, but it's saying that it's related and enforced by an administrative body, such as Department of Labor or State of Michigan Fair Employment Practice Commission. So you're talking about like kind of like some of the quasi uh, governmental bodies that are governed and used under this. I would even go far as to say that regulatory law is when we're dealing with child support.
Yeah, it's
Uh,
administrative law. It's
yeah,
another
that's what I'm saying.
term for it. It's pretty much the same.
It's a
Regulatory law
regulatory law, right?
is it's a
Child support,
right.
CPS,
Yeah,
child protective services, all these type of things. Those are under regulatory law.
right.
So
Administrative.
understand that that's different than statutory law.
Right.
Statutory law, um, like traffic violations and stuff like that, are pretty much under statutory law.
Right.
Even your criminal cases, your criminal, your crimes and stuff is under. I know it's CFR, but I mean, our crimes are commercial, but not to get into that. But as far as statutory law, I think like crime and stuff like that is all under statutory law.
Yeah, it's
So
under statutory law. How they? I told you once. Like we'll do a show on that.
yeah,
They
yeah, yeah. I'm just saying.
they
I mean, I'm
right.
just
They're
showing the difference between what
Article
regulatory
One.
law would be. Like regulatory
Right.
law is dealing with child support and different government quasi governmental bodies that
Right.
deal, and that's administrative. But then you got the statutories, which is like your criminal stuff, your civil stuff. Those would be under statutory law because Congress, your Congress or your legislative body in your state has created a law for it. So
Right.
I'm just
So
showing the difference between the two.
let me put it in, clear it up in context. You will have an administrative body, right, over that statutory law. Child support is administrative, but they enforcing what? Statutory law. So you going through an administrative office that has the right to enforce, you know, statutory law because they're intertwined. It's administrative office. So you got to look at that, right? So you got these administrative judges that's over these bodies, and what they do is they enforce statutory law, but this administrative office. So, and I'll be able to break it down to show you what's going on, because like I said, it can be a little sophisticated process. But please continue, Chief.
You good, brother? Um, so okay, now so we're looking at jurisdiction. So now saying that all of any or all of these categories might apply to any given topic. Now I said relating to women, but in general. So it says in many instances, these laws are interdependent. Although they may appear to function independently, to add to the complexity, these types of laws are created by appropriate body in each of the different jurisdictional units.
See, they
So
explain
now,
it there. They
huh,
kind of explain it to you right there. It says complexity. These types of laws are created by the appropriate bodies. Those are the administrative offices, right? In each of the different jurisdictional units, right? When we're dealing with legislative law based on the category of law, right? You'll have an administrative office over that category dealing with that particular subject matter. That makes
check.
sense.
Yes, sir. Check, check. Um, so we got, let me see something. Okay, I just wanted to check the board. Uh, so now it's saying that each of the different jurisdictional units, which is so we got federal, state, regional, county, and city. So in other words, each jurisdictional entity has governmental bodies. Hold on, I'm gonna do something real quick. Let me zoom this in a little bit. All right. It says in other words, each jurisdictional entity has governmental bodies that create common, statutory, and regulatory law. Although some legal issues are handled more often at the federal level, while others are in the domain of the states. So, for example, civil rights, immigration, interstate commerce, and constitutional issues are subject to the federal jurisdiction. Issues such as domestic relations, domestic violence, marriage, divorce, corporations, property contracts, and criminal laws are generally governed by states unless there is a federal preemption. So then it says state laws and terminology will vary from state to state, and there are few comparative guides available. It is better to look at the specific state laws or court decisions, or to compare several specific states' law and court decisions, rather than to attempt to generalize about the legal criteria followed by all states. So I know you got something to say about that, brother.
It kind of it broke it down. So it
Yeah.
says where the federal law preempt, right? So what happens is there's a federal statute that the state adopt. It is birthed out of that federal statute, in which pretty much the feds got jurisdiction over everything, because everything is created on the federal level. Because you got to think about this. Everything starts off with the Constitution. The Constitution is a federal jurisdiction that created everything else, right? States used to be independent, but they ratified and they came under one central body. So now we're talking about the federal jurisdiction itself stemming from the Constitution, and the Constitution created the three branches, and then the three branches created their own. They had to do the separation of powers. They created their own administrative bodies to govern their specific jurisdictions based on the subject matter, right? Dealing with the categories of law. So each branch of government has its own specific, specialized, or exclusive jurisdiction that it deals in, dealing with particular things, the subject matter. So you have to understand that to the degree, and you need to understand because we're talking about equal protection. So when you talk about equal protection of the law, you got to look at with that state based on a particular statute when dealing with the Supreme Court. If a person, that one person had that a particular right to exercise such thing, all parties have a right to exercise that particular such thing dealing with under that subject matter jurisdiction.
Check. So, and also to add to that, like just to go back over a little bit, it's like, it said, for example, civil rights. So, like when you got uh, when you got like a civil rights violation, that's going to go to federal court. You know what I'm saying? Like, or like, um, it wouldn't go to like your local court, like your county courts. And another thing too, each state has different type of like their court is set up different. Like you got like there's like in Ohio, we got our county court is with the common pleas court, right? Uh, but if you go like to Virginia or something, it's not called that. It's called something else.
Right, right.
Um, you know, they got like what's it called? I forgot what they call it, but it's
You got
like they're
superior courts.
yeah,
You
yeah,
got
yes,
they got different court names I can't think about. You got those superior courts, and then what we have common pleas. Then we have municipal courts. Um, those is various different types. So you need to
right,
understand all of that. And then
and like
a lot of
mhm,
us, when we gonna go over tonight, you also need to know the local rules of that particular court that you're going in, because that's the standard of operation that most people overlook. They'll argue, these procedures, but they won't even look at the local rules. Before you walk into court, you shouldn't be familiar with the local rules, because that can disqualify anything of your pleadings if you're not following the rules. Like, for example, what if they say in that local rule that all documents have to be typed in black ink and you got yours typed in blue ink? That can disqualify your motions because you didn't follow the local rules of the court. And I'll show you this within this, and on this show we'll go into some of these elements and talk about some of this stuff, right?
right, right. Like even like with like sometimes you got to have a cover letter. Like I know, like sometimes I never had a cover letter on certain courts, but then certain courts they require it a cover letter, a cover page. So it's just like little small things sometimes that you know that they'll want you to do that's different from one court to another. So you always just got to really look at those rules of that court. Um, so we got case law. You talk about case law. I'm not gonna go through this whole thing, but it just says when your legal research involves case law or common law, it is important to know something about the significance of precedents or the doctrine of stare decisis, which refers to adhering to or abiding by settled decisions. Simply put, lower courts are bound to follow decisions of higher courts in the same jurisdiction. So, for example, a federal district court in Maryland is required to follow the decisions of the Fourth Circuit Court of Appeals and the U.S. Supreme Court, but it is not bound by the decisions of other district courts or by the Maryland state courts. So, what do you got to say about that, man?
So we
What
got
do you
to
think?
so that's what I'm saying. You have to look at like these courts, like they're caught up in districts. So a lot of people don't know, like you got 11 districts. And within those 11 districts, you have bundles of states. And those states are each within those 11 districts. So For example, when it talks about Maryland is required to follow the decision of the Fourth Circuit of Appeals in the Supreme Court, they're within that circuit of courts, within that jurisdiction, they're in the Fourth Circuit. But it's not bound for the decisions of other district courts or the Maryland State Court, right? So when it's talking about the federal district court, right? So the federal, right, it preempts the state court, right? It's a higher court. So when the state court make a decision, right, it don't have to be aligned with the federal court, but I mean it has to be aligned with the federal court. But if the state court make a decision or the federal court make a decision, it don't have to be aligned with the. So if the when the federal court make a decision, right, it's gonna fall on the state court. But if the state court make a decision, the 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 federal court don't necessarily have to honor that ruling.
Gotcha. Gotcha. All right. So, um, for the sake of time, I'm not trying to stay stuck on all of this, but let me see. Okay, so let's move on to statutory law real quick. It's saying we talked about statutory law, but it's saying statutory law can be found in two types of publications: complications of statutes or codified laws. Both the compilations and the codes have the same wording, but their are different. A federal law is given the number of the U.S. Congress that passed it, and the second number that represents the chronological order of its passage. So, publication L88 352 indicates the 352nd law passed by the 88th Congress. So, after passage, a law is codified or published according to its subject category. It says Public Law 88 352 can be found in the United States Code, where the citation is 42 USC 2000, etc. sequence. Remember, though, that not all laws, hey, now this is important. Remember that not all laws are codified. Okay, so I don't know if you got anything to say on that.
Right. So you got to look at some laws, or that's why we're dealing in case law or the common law. Some law is done created through the court decision, because sometimes you might have a statute that may be vague or whatever, and they have to make a decision, and that law is based upon the court. Those case law are not codified. So when we looking at everything about understanding the law and looking at how the law work, and they're looking at these administrative policies and codes, and some of them are just policies. Everything is not codified when dealing with certain administrative venues or dealing with certain rules or policies. So we have to look at everything in the totality to understand the complexity of the jurisdiction and how to properly address these issues. Because I tell people, the better well informed you are, the better you will have success in the courtroom. The least informed you are about these rules, policies, codes, procedures, and all of that, and how there's so many moving parts within the jurisdiction, the least informed you're gonna struggle with being able to present and articulate certain matters in a certain way that will shed light on the case and the issues or conflicts at hand to determine if the court is in violation of what they're required to perform.
Check. Okay. So this is my last part that I'm probably gonna deal with on this part. Um, and it's the regulatory law. So this goes back into what we talked about with like different agencies. So it says administrative agencies serve two major functions: rule making and adjudication or enforcement. The rules and regulations of administrative agencies and executive documents are generally published in a register and compiled in a code. For example, federal materials are published in the Federal Register and the Code of Federal Regulations. So we talking about them CFRs. It says that the state of Michigan publishes the Michigan Register and the Administrative Code of Michigan. Decisions rendered by the agency's adjudicatory, adjudicatory body may be published as well. If a decision or order is not published, anyone wanting a copy must contact the agency to receive it. Okay.
Yeah.
So, yes. Go ahead, brother. I know you
So
ready. I know. Go
yeah,
ahead.
so they do this a lot. So like I won a few cases, right? And then they like you have to request those. Like you won't find them on the internet or you won't find them published anymore. They'll put them like they kind of like hide them. And if you don't know, if somebody can't tell you the case number or whatever in reference to that case or whatever, you're not gonna get it. So they do that all the time. So they publish the cases they want you to see, and then the cases they don't want you to see, they don't publish. They keep them in. But they do have them, but you have to request for them. So just like in what it was saying, the administrative agency serves as two major functions. Could you scroll back
Okay,
up
brother.
where I can see the whole thing?
Yeah, my fault.
Okay, so it says rule making and adjudicating for enforcement, right? So they letting you know the legislative and the executive branch, Article 1 and Article 2, are working in conjunction. So a lot of people do like, well, how is this and that? You have to understand if you go and look at them, if you look at the revenue laws were adopted by what? That is a branch of who? The executive branch. The Internal Revenue Service is a branch of the executive branch under Article 2. But what happened? It created the IRC, and then what? The USCs adopted those IRCs and put them into what? Their jurisdiction through its adoption. So based on what it did, it adopted the IRCs, the Internal Revenue Codes, into a United States code. Now that gave or granted the right of the executive branch to start utilizing those commercial those commercial laws into that jurisdiction because it just adopted an agency laws into a United States code. And they doing that through, and now they're intertwining the jurisdictions. And you don't understand that the law, the CFR, was originally on the federal side that the legislative side adopted and put it into their jurisdiction, and now it's a statute under Congress. So they do that all the time. So a lot of people, that's how all crimes are commercial, because they merge the two jurisdictions.
Okay, brother. That's heavy. Go ahead.
So this letting people know this can get a little more sophisticated than what it looks. So we try to make it a little more simplified. So that's why we're able to do this show. And as we start building up the show, we'll start laying it on y'all a little bit heavier. As you can come along, you'll be able to keep up with what we're saying.
Facts. So
Why am I
that was,
lagging?
huh?
I'm lagging.
Yeah, I was too. I'm lagging a little bit too, man. I don't know. I'm not understanding what's going on. I'm usually not lagging like that.
We the pro
Uh,
say no.
they're trying to stop the flow, but you can't stop the flow. Can't stop the shine. So that's really my spiel as far as that go, man. I know you wanted to get into a particular part.
So we're
So
gonna get into the traffic, right? We're gonna start talking about these traffic. But we went over jurisdiction. We're gonna get into these traffic because I wanted to talk about some things, but I want to get into the traffic rules so you can see this and start understanding how to deal with the courts based on the traffic rules. So these are the rules of procedure, right? That you need to know. You also we're gonna get into the local rules of that court. I'm gonna show you. Also, you gotta look at the local rules also because they also work in conjunction with the traffic rules. So I'm not gonna go through this whole thing because it's kind of short, but I just want to point out some key things. So it talks about under the applicability. These rules prescribe the procedure to be followed in all courts of the state in traffic cases and supersedes the Ohio rule of practice and procedure in traffic cases. Now, this falls under a particular statute. So the rules supersede. So when you see these rules, these are the governing rules. These are the procedural policies. When we talk about procedural due process, this is one of the elements we're talking about on procedure. That long as you following these procedures, the court should be adherence to long as you within the confines and you did everything timely, following the instructions of the procedures, you should be able to um, just to keep up. When you win your case, that's going to depend on how well you inform with case law and everything else. So you need to know these rules, right? Then it says authority in construction. These rules are promulgated pursuant to the authority granted by the Supreme Court. They don't say by Congress or by the executive branch. You now it tell you who has jurisdiction. It says by the Supreme Court, by the RC, this right, and this. The RC is the revised code. So it's telling you that it's granted by the Supreme Court and by these legislation. So now the grant is by the Supreme Court, but in conjunction with the General Assembly revised code that lays upon the state. So you got to understand where these codes, where they lie at, who got jurisdiction over what. What is the agency or department that controls that particular language and who has the right to rule on that subject matter? So that's very particular that you understand who is governing what and what agency falls within that particular jurisdiction and how they have jurisdiction over that particular subject matter. So they just told you right here. So if you had to appeal this, since this was granted by the Supreme Court, they will have the ultimate say in accordance with this rule also, showing that you're working in a dual jurisdiction. So now you're looking at this Supreme Court and the legislative body, the General Assembly, right? So they showing you the duality within the jurisdiction. Then now it's continued. They shall be construed and applied to secure fair, impartial, and speedy and sure administration of justice, simplicity, uniformity in the procedure, and the elements of unjustifiable expenses and delays. So they letting you know. So these rules is not to hold everything up, it's to go fast. It's trying to align itself with the Constitution. And so is you looking at equity within the secure fairness, impartiality. Then you're looking at speedy trial. That's a constitutional fold. Administrative of justice and simplicity and uniform in procedure. So these are also aligned with the constitutional practices that you can also use because they have to follow the Constitution. Okay, and then it says court orders regarding physical appearance. As used in these rules, any option to use live two-way video or audio technology shall not be construed to limit the power of the judge or administrator to order that the party or attorney or witness physically appear at the proceeding without the use of the two-way video or audio technology. So this is according to the rules, right? They gave the judge discretion. If it said that the judge didn't have discretion, if a party had the right to exercise his power and the judge couldn't take it away, then there would be an abuse of discretion if the judge didn't allow you to exercise such right based on the construction of this rule. So y'all got to go through y'all rules, right? So I'm not going to go through everything, right? So let's look at um, complaints, right? Traffic complaints and summons. If in traffic cases, the complaint and summons shall be the Ohio Uniform Traffic Ticket as set out in the appendix of the form. So they tell you, here's another rule that most people overlook. It says in traffic cases, the complaint and summons shall be the Ohio Uniform Traffic Ticket. So now you got to go to the Ohio Uniform Traffic Ticket and look that up. So a lot of people don't do that.
Yeah, nobody doing that. Like how many of y'all doing that?
Right?
Fact.
Because most people ain't reading these rules. We ain't even got into all of that. That's why I say you must abreast yourself with the rules. You got to know these rules, family. If you don't know these rules, you're going to be in danger of losing your case because you don't know the rules to the game.
Thanks.
It says the Ohio Uniform Traffic ticket shall consist of 4 sheets padded together and bound at the top or bottom edge. Each sheet shall be 4 1/4 inch in width and 9 1/2 inches in length from a perforation below the binding to the bottom edge. Right?
Right.
And then it says the first sheet shall be white, and the second sheet shall be canary yellow.
What? What are you talking about?
They talking about the traffic ticket itself.
Oh, okay. The ticket.
They
Right.
describing the whole process of the traffic ticket, so you would know what all the sheets said, right? This is stuff.
I mean, because you only get. I mean, you only get one.
They give you one. They tear you off and give you one, right? But they telling you the first layer of this thing is supposed to be it's the first page. In the first sheet shall be white. Then the second sheet is canary yellow. Where additional copies is needed by an agency, it may be added. The first and second sheet shall be at least 15-pound paper. These are things that they have to follow. These are the rules.
crazy.
right? So what if they give you the yellow copy? What copy do you supposed to receive? What if they don't have the white sheet in discovery? What are these things? These are stuff that you need to know. If you don't know these rules, you don't know what to ask for. You don't know how to apply the scopatory prowess of these rules in the form of discovery matters to determine if what happens if the white sheet is not there. They lost it. Do they have a case? These are
Right.
questions of law that needs to be answered and discussed. So then it goes to the first sheet shall be the court record. The second sheet shall be the abstract of the court record for the Bureau of Motor Vehicles, as required by Section 4507.021 of the Revised Code. So the first sheet go to the court, and the second sheet go to where? The BMV. How many of y'all know that?
Right.
The second sheet may be omitted from the ticket if the court reports violations to the Bureau by electronic or other means acceptable to the Bureau.
Interesting. Interesting. And now, each state is different too. So y'all, understand that if you're looking at
So,
it out
yeah,
of this state.
I'm just giving y'all, I'm not going to go through this whole thing because it'll take too long. But these are things and steps that, so let's go down. Issuing of tickets to enforcement agencies. The judge in a single, it says the judge in a single judge court and the administrative judge in multiple judge courts shall be designated the issuing authority for tickets and prescribe the condition of assurance and accountability. Let me read that to y'all. I think that went over y'all head. The judge in a single judge court, the administrative judge in a multiple judge courts shall designate the issuing authority for the ticket and prescribe the condition of the issuance and accountability. The issuing authority may be the clerk of the court, the violation clerks, or the enforcement agency of the municipality.
Okay. So break that down.
So it says the
I mean,
issuing
what do you understand?
So
Go ahead. Go ahead.
okay, so this is what I'm trying to tell you. The officer giving you the ticket, he's following the what? The administrative judge, right? They the issuing authority for the tickets and prescribe the conditions of the issuance and accountability. So they are over these police forces, right? And they the ones who determine if the officer is in compliance or not. These are things that most of us overlook. The issuing authority may be the clerk of the court. Let me say that again. The issuing authority may be the clerk of the court, the violation clerk, or the enforcement agency of the municipality. So they're telling you the different roles that these people can play. So it could be the administrative judge, it could be the issuing authority, it could be the clerk of court, the violation clerk, or the enforcement agency of the municipality. It says when a single enforcement agency except the state highway patrol regularly has cases in more than one court, the ticket used by the agency shall be issued through the court for adult in the most populous area in the jurisdiction of the agency. Tickets are used by the state highway Way Patrol shall be issued by the superintendent of the State Highway Patrol. Totally two different jurisdictions. So now you got the State Highway Patrol that you can now get a Freedom of Information request from, or you can subpoena to court. So without knowing these rules, guess what? You can request right discovery from these could be a question in court. Who is the issuing issuing authority in this matter, Your Honor? Is it you? Is it the clerk of court? Is it the violations court? Is it the enforcement of the administrative agency? Now you can hit the discovery with whoever have the issuing authority based on the situation of the court. Most people don't know that, right? Then you got the Highway Patrol that you can ask for discovery matters on particulars based on their rules. So now you got to go to these agencies, right? You got to look these agencies up and determine their policies on how they handle these things. And then they handle these things according to their policies. These things can be what? They can be issues of disqualifications to get the case dismissed. If you ain't reading these rules, you won't know. Am I making sense, Chief?
Oh, you're making a lot of sense. Definitely, man.
So, duty of the law enforcement officer. A law enforcement officer may issue a ticket, shall complete and sign the ticket, serve a copy of the complete ticket on the defendant, and without unnecessary delay, file the court record with the court. You hear what it says? File the court record with the court. This is a court record. They gave you a ticket. It's a court record. It became a court record. He's operating for the court. They're telling you who he's working for. If the issuing officer personally serve a copy of the complete ticket on the defendant, the issuing officer shall note the date of personal service on the ticket in the space provided. If the issuing officer is unavailable to serve a copy of the complete ticket on the defendant, the complete ticket may be served by another law enforcement of the law enforcement agency issuing the ticket, or file the ticket with the clerk of the court for issuance of warrant and summons under Criminal Rule 4. So now they're showing you that the criminal rules are also what? Applicable under this jurisdiction. So you got the traffic rules, and I'm going to show you that the civil rules is also applicable, and you got the traffic rules. So you got three jurisdictions that can be all applicable under this same thing. And we ain't even talking about the rules of evidence. So you guys, and we ain't even talking about the local rules. So you're required to not only know the local rules, the traffic rules, the rules of evidence, along with the rules of criminal procedure and traffic and civil rules.
Check. And I was going to ask you about that because, when we've gone to court, when I've gone to court, we go in there and ask like, what jurisdiction is traffic, and they'll say, I'll ask them, they'll say it's criminal. And the judge will say, traffic court is it's quasi criminal, and I'm like, what does that mean? Is it criminal or not criminal? So what you just said, like, it's really got three different type of jurisdictions that are intertwined in this. And so how is that possible? Like, how Is that fair? I mean, like, can that be challenged?
Well,
You know
this
what
is
I'm saying?
why these institutions they adopt each other's rules and things through adoption. That's just like let's say me and you got a business, right? And then you say you're gonna adopt my policies, and then I adopt your policies. Now, the adoption of your policies and my policies are within our business infrastructure for our employees. Now we tell employees that you have to also read this manual based on the service that we're intertwining with you or whatever business that we're dealing with. So, I mean, these are this is the rules of the game that a lot of people are not really familiar with.
I got you.
You see what
Yeah.
I'm saying? And this is why, this can get very heavy on the average person. So let's further get into this. Tickets that solemnly allege one or more minor misdemeanor violation must initially be issued by the summons. Okay? The officer shall notify the defendant if the defendant does not appear at the time and place stated in the citation or comply with Division C of subsection of section 2935.26 of the revised code. Defendant's license will be canceled. Defendant will not be eligible for reinsurance of the license or insurance of a new license for 1 year after cancellation.
Hmm.
And the defendant will be subject to any applicable criminal penalties. So you don't show up, they can block you from getting your license. They can not allow you to get license plates. So these are things that you need to know, right? So I'm not, like I said, I'm just going over some things. So let's go plea rights and upon plea. And then we'll get into some other stuff because I'm going to skip some of this other stuff and get into this, right? Please, right upon plea. A defendant may plead guilty, not guilty, guilty, or with the consent of the court, no contest. All pleas may be made orally. If the defendant refuses to plead, the court shall enter a plea of not guilty on the behalf of the defendant. So this is what they're gonna do. So this won't be an abuse of discretion if you don't make a plea. The judge is gonna plead for you, right?
Yeah,
So
a lot of people, and a lot of people go in there and they're like, I can't make a plea, Your Honor, because I don't know the jurisdiction of the court, right? And
right. So
so,
he
and
he
so
has
then
to
the judge will make a plea for you, and
right
they're like, objection, objection, but
based
right
on these
there,
rules, he has the right to do so.
right,
Right? So it won't be an abuse of discretion because he's allowed to do that. A lot of people know that. Then it says effect of guilty or no contest pleas with reference to the office or offenses to which the plea is entered. The plea of guilty is a complete admission of the defendant's guilt. Now, this is what I want you to understand. When you is found guilty, you waive all other rights that you cannot later claim. So, for example, you cannot sue them if you then say you were guilty. If you plead guilty, that's what they call a confessed judgment. Now, a plea of no contest is not an admission of the defendant's guilt, but is an admission of the truth of the facts alleged in the complaint, and such plea or admission shall not be used against the defendant in subsequent civil or criminal proceedings.
that's interesting right there.
So, if you go in there and plead no contest, right, they can't use it against you. You're going to agree to the facts. Now, they can't use that in and against the defendant in a civil or criminal proceeding. This matter is already settled. This is where you would get a stare decisis ruling by the Supreme Court. And it says, when a plea of guilty or no contest is accepted pursuant to this rule, the court shall proceed with the sentence under Criminal Rule 3.30, Criminal Rule 32. So y'all need to understand, here we go.
Yeah.
The criminal rule is applicable to these traffic rules. Once again, they're showing you they are applicable. They work together.
Yeah, I
So,
see.
so I ain't gonna go through all of that. Now, let me see. It was something I wanted to show. So let's go here. Procedures not otherwise specified. If a procedure is specifically prescribed by these rules, the criminal rules of procedures and the applicable law applies. Now, this is what it says. I'm sorry. It said, if no procedure is specifically prescribed by these rules, the criminal rules of procedures and applicable law apply. What are they talking about, the applicable law? They're
Yeah.
talking about the civil rules.
Mm, okay.
You see what I'm saying? Because we can go to the civil rules, right? Because I ain't gonna go through this whole thing, right? I just wanted
Right.
to show them a little thing because you have to know this and you have to follow up your rules. But let's go to Ohio Civil Rules of Procedure, and they're gonna tell you.
All right. Y'all in here, please like, share, and subscribe.
So let's go.
Appreciate it. I'm waiting for it to pop up.
Okay, we're gonna go back. I'm gonna set it up. We already an hour in. I'm trying to. So let's go here. What did it say? There shall only be, there shall only, it says, there shall be only one form of action, and it shall be known as a civil action. There's only one form of action. It's a civil action. And then we're going to get into the other stuff, but I'm just trying to show you that you got to know the rules of evidence, the rules of civil procedure, the rules of criminal procedure, right? The rules of civil superintendent, especially if it's dealing with the highway patrol, right? And you got to know the traffic rules. So if you guys are not real versed in these rules, and I ain't even saying the local rules, you still got to know the local rules. So let's go to the local rules. I'm gonna stop sharing that. Let's go to the local rules, right?
All right.
I ain't even talk about the uniform rule. I'm finna show y'all that in a minute too. Let's go to the local rules. I just had it pulled up. The local rules of the court. Here it go. Now let's go here. So these are all the moving parts, family. It's a lot of
Yeah.
things that you have to know. Here's the local rules. Common pleas local rules. How many of y'all know the local rules of your court? Scope and applicability. Let's go here. Scope and applicability of these rules. The rules hereinafter set forth shall apply to the general provisions of the Court of Common Pleas of Hamilton County, Ohio. The purpose of these rules is to bind local practice and procedures of the court, consistent with the rules of superintendent. You see that? Hold on. You see that? So you got to know the the local rules, the civil rules, the criminal rules, the traffic rules, rules of simple, the rules of superintendent, and the rules of evidence.
All these damn rules, bro.
I'm just showing you how all of this stuff, right, are intertwined. Most of y'all not studying this. That's why I've been screaming this for years. Most people don't know all of these different rules, right? And then you talking about you still got to know the Constitution. We ain't even. So the rules of civil and criminal procedures. Here we go. Didn't I say that? The rules of civil and criminal procedures and such other rules. Here we go. And such other rules as may be adopted. Didn't I say they adopting each other rules?
Yes, sir.
Didn't I say the federal is adopting the three branches of government are adopting each other rules?
Yes,
This is
sir.
how, and they got the separation of power doctrine, right? But they have the power to adopt each other rules or promulgated by the Supreme Court of Ohio pursuant to Section 5 of Article 4 of the Ohio Constitution. I ain't even talking about the Ohio Constitution. Look at all of these moving parts.
That's another aspect. The Constitution, state Constitution.
State Constitution. So you got to know the state Constitution on top of the federal Constitution and all of these damn rules.
Right.
Additional local rules of the court may be adopted by the domestic relations. You see that? Probate, juvenile division, and such other divisions of the court as may be created from time to time, governing practices and procedures in those divisions. The Court of Common Pleas of Hamilton County consists of 4 divisions: the General Division, the Domestic Relations Division, the Probate Division, and the Juvenile Division.
Right.
So there's 4 branches of these divisions. They got 4. So when you're dealing with traffic, you're going to fall under the what? General provision. It's not domestic, it's not probate, and it's not juvenile. So I'm just giving you this all of these moving parts that most people are not telling you, right? So let's go down.
I want to get some time in so we show this video too, bro.
Okay, I'm all right. So let's go to pleadings and other papers. And this will be it on that. So pleadings and other papers shall be by what? You see that? They can disqualify you if you're not in compliance with this. Pleadings and other papers shall be printed on 8.5 and 11-inch paper. All pleadings and other papers for general division cases assigned as A cases number classification shall be filed electronically in accordance with the local rule 34 unless the party is proceeding pro se. Deposition, administrative records, the trial transcripts, and other large multiple page filings are exempt from this requirement. Filing is effective when the clerk of court files a stamp and a document, a stamps, a document, and a docket in the case. The electronic version of the document, whether filed through an e-filing or received by the clerk of court in a paper format and subsequently scanned into the electronic format, constitute as official record in the case. You see how the attorneys got it?
Yes, sir.
You got to get yours stamped. All of that if you operating as pro se, but all they got to do is file it into the electronic filing. And if long as it make it, they can file it late. They got a tactical advantage over you. because they can file their stuff late and then hit the system. And if you don't pull the electronic filing to show when it was filed or whatever, you won't know. So these are things that you have to look through and understand according to these rules. If you don't know these rules, right? Because you can disqualify their pleadings if they're not following these local rules, or you find them cheating. They filing or backdating and filing stuff that and this stuff happen all the time. So I just wanted to go through these things to show people we can go through and look at the video. You ready?
Yeah, we got this video, man. We got this dude. He like to run his mouth, man. Little dude. He likes to get on sovereign people. Um, so we're gonna show like, because a lot of us that's watching these videos as Moors and whatnot are coming at it from a different angle than even what we're talking about here, right? So we want to show what happens when you go in court talking about jurisdiction, right? And how it's perceived so that you can know how to deal with it. So let's get into this.
To deal with a sovereign citizen who appeared last week with probably the stupidest haircut and an IQ to match. So let's begin.
Bernard, Brandon Little.
Speaking. Yeah.
City of Detroit, which is Bernard Brandon Little, case number SB 1513015, counts 1, 2, and 3. SB 1513091, SB 1556287, counts 1 and counts 2. SB 1556352, counts 1 and counts 2. SB 1556353, counts 1 and counts 2. Appearance for the record, please.
Elwood Berry Jr. on behalf of the defendant. State your full name, Mr. Little. Bernard.
Your full name?
Bernard. I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me, the caps. I'm not that caps.
So who gave you the last name Little? Your mother?
The government did.
Your mother didn't give you that last name?
The government gave it to me.
She had to tell the government, didn't she?
The government. She was an agent of the state.
She was an agent of the state? All right. What are we going to do with these cases, Mr. Little or Mr. Bernard?
I would like to know which jurisdiction I'm being tried under so I can adequately defend myself, Your Honor.
I still don't understand why they even bother asking what
Here we go.
jurisdiction the courts are operating under. I mean, I get it. They think that the only jurisdictions that exist are maritime admiralty and common law, but they neglect to accept that in all 50 states, either the state constitution or the state Supreme Court has well defined the jurisdictions of the district, circuit, probate, and other courts. But I can talk all day about it, and they're not going to listen to me because they do their own research. So Judge Perkins' answer is way better than mine.
Read the court rules. I'm not here to give you a law school instruction.
I just want to pause it. Did you hear what he said? He said what?
Read the court rules.
Read the court rules. Period. So that's why we going over what we went over, y'all. Because y'all could go in there talking that stuff, but this is what's gonna happen. So you need to know the court rules in order to apply it back at him. Because if you start throwing the court rules at him, now what he gonna do?
Read the court rules.
What do you mean? As a matter of record, I would like it to be placed on a matter of record how I'm being what venue you are using, Your Honor.
That's not my obligation, okay?
What do you mean it's not your obligation? It is your obligation. You took an oath to uphold. Excuse me.
Mr. Little.
Yes, sir.
Let's stop, all right?
What do you mean stop?
Don't talk while I'm talking, first of all.
Yes, sir.
All right. Secondly, it is not my obligation to read you the court rules. You're here. If you don't want a lawyer that is...
I'm not asking you to read me the court.
I'm not finished talking. If you don't want a lawyer that's versed in the rules, then you are obligated to know the rules yourself. Okay? So all of that, what kind of jurisdiction it is and all of that stuff, I'm not here to teach you that. I'm here.
You're not here to teach me, but you're here to inform me what jurisdiction that you're operating in, so I could defend myself. I'm not asking you to teach me.
All right, you got anything to say real quick, man? I know you. You got anything to say what he's saying?
Yeah. So he's trying to say, okay, under the Sixth Amendment, he has a right to understand the nature and cause of action. He's have a right to be informed. And what a lot of people, they don't put it out there right. And
no,
what
he didn't say that. Yeah, he didn't say under the Sixth Amendment, I have the right to know the nature. He didn't say it.
So he's saying the jurisdiction. We know that jurisdiction is vast. So he's using the wrong language under the wrong construction. He needs to use the constitutional language under the proper construction to get the judge to what? Operate correctly and obey his constitutional instructions, because he has an obligation. Because you got to remember, the first 10, right, is the Bill of Rights, and that's where due process come in at. So it's a bill on the court, and they have due process, and it's a requisite that they follow this. They can't get out of it.
Right. All right.
Me anything. You're not teaching me anything. You're notifying me of what jurisdiction that you're operating in. Are you operating in commerce? Are you operating in military? What capacity are you trying me in?
Hey, I'll give it to him. This is the first time a sovereign fuckstick has referred to the courts as a military jurisdiction, but it still doesn't change the fact that the jurisdiction is statutory and in the district courts as defined by the Michigan Supreme Court and codified in MCR 6.008b, which reads, the district court has jurisdiction over all misdemeanors and all felonies through the preliminary examination and until the entry of an order to bind the defendant over to the circuit court.
Okay. Quick. You got something to say on that?
So let's break this down. Let me break this down, right? So a lot of you guys, when you're trying to go in there and you're trying to give appearances, do it all in paperwork. I can show you a quick constructional breakdown. When I go in, I hit them with the notice of appearance. Now, once we hit them with the notice of appearance, now you want to hit them. If you're going to ask for the nature and cause according to the Sixth Amendment, put it in a motion. Put it in a motion. Why? Why you want to put it in a motion? Because you're creating a record. Evidence is going to be timestamped. Now, what else would you want to do based upon that? So once I put it in a motion, they have a duty to tell you that is conferred upon the prosecution. The judge have to make a legal determination. Once they fail to do that, what else would I do? How I would do that? I would handle that. I would file it in the form of Brady discovery. So it would be a motion for, right? And it filed, since it's under the Sixth Amendment, it will fall under Brady discovery, not only triggering the cause of action. Now you can hit them with also, you can put a time computation on there. What do I mean by speedy trial? They got 30 days. And if you will hit them with a motion for sanctions. What is the motion for sanction for? Now you can say they're violating within 30 days. They can't do it. They're in violation of speedy trial. Now you compelling the court, right? To now you get your motion for sanctions and your orders and your affidavits together, and you put all of that in the one motion. They got 30 days. And then you put in a motion for also a motion to for dismissal for failure to state a claim. This is how you make these little traffic issues go away like that.
No
Like
doubt.
that.
Well, yeah, that's some work. It's a little work though, but for
That's
sure.
what we're here for. That's what we're here for.
Exactly. Right. That's what we here for. All right. So
And I'm
I'm
demanding you tell me what are what process are you charging me of? Or are you charging this fiction of? Are you trying to get the bonds? I'm trying to figure out what's going on. You haven't notified me in the capacity how to defend myself.
This is district court. These are criminal cases.
yeah,
Read the
muted him.
Michigan rules of court.
That's not explaining which venue you are attacking me with. That's not what court. The court is the court 36th district is not a venue. It's a place. It's an establishment.
It explains everything.
It's not explaining nothing. I'm asking you to explain which jurisdiction are you heading me in? That's a simple question. Why are you running from the question? That's the answer. What's the problem with you answering the question, Your Honor?
You're gonna be the third person that I give 30 days for contempt of court to if you do not.
Why would you do that? Why would you do that, Your Honor?
Because you won't shut the fuck up. You remember when you were just a young troglodyte
This
and your
dude.
mother would tell you that if you don't close your mouth, you're going to have to go stand in the corner where everybody pees for 5 minutes? Well, this is the same situation, except Judge Perkins isn't your mother, and that 5 minutes in the corner is 30 days in county jail.
Wait a minute. There's gonna be some proper decorum in here, right? You're not gonna sit here and you're not gonna overtalk me. I've given you the answer to your question. If you don't like the answer, let me finish. If you don't like the answer that I'm giving you, then you file a motion on whatever you think jurisdiction is and wherever you think the case should be dismissed.
It's not.
Boom. Okay, so let's stop it right there. Okay. So the judge is prompting him. He's telling him what he needs to do. The brother is went in here and he's going rogue. He don't have anything filed. I haven't heard the judge read anything that he filed. He's going in there off a premise that it's a corpse, that he needs to know the jurisdiction. But he's arguing this without any motions or anything of that nature that's been presented in court. I mean, like, you know what I'm saying? Like, you can't you got to have a motion or a writ or something in that nature. Like, you can't just go in there with an affidavit. That's not gonna work either. You got an affidavit arguing that. You need a notice. You're gonna need a notice, a motion, a writ, or something like that. Okay. So what you got to say on that, King? Oh, King gone, man. All right, so I'm a oh, there we go. Okay.
Okay. I don't know. They
Okay.
trying to
You
kick
got
us
kicked
off.
off.
Trying to kick us out. They're
Trying
trying.
to kick you off. So I was saying though, like this brother going in there, and the brother ain't got nothing written down. He ain't got nothing that he presented to the court prior to coming in here. He sounded like he just running off at the mouth, right? So I was just saying, like, he need a writ, a motion, a notice, or something. He can't go in there with just an affidavit. What do you got to add to that? Because you seen this video, right? Or do I need to go back a little bit because you got kicked off? You there? Oh, I don't know, brother. But okay, I'm gonna keep it going though. I'm gonna hit the I'm gonna keep it going, y'all.
About what?
Check
Now
it out.
you about to go there, all right?
Yeah, hey, he pisses the
One
judge
more
off,
time,
y'all.
you interrupted me, and we're gonna go there. I said that gives you your opportunity to speak to the court through a motion. So whatever you say, whatever kind of path you want to take with these cases, I'm going to give you the opportunity to do that. But you have to put it in writing now, okay? So I can read it, the city can respond to it, and then I can make a ruling off of who I think is in accordance with the law. All right, Mr. Little?
All right, y'all. So okay, I just want to say, like, this is the thing. When we go to court, this is why we're saying, like, y'all, if y'all late to the game on this video, y'all need to go back through the video. Okay. If y'all thought it was boring, it's boring, but it's vital information. Y'all can act like it's boring if y'all want to, but what's really being said is we're showing you the rules of the court. We're showing you what the particular laws that you're going to have to spit back at this judge, because the judge is based on certain perimeters. He's not going to just listen to this dude rattle off stuff in court. He needs to show the judge what he's talking about through law. If it's case law, which is common law, he got to put it in a motion or some type of writ. He got to show him something so that he can argue that. And if the judge is not able to argue that or articulate it back to him, at least he's got a paper trail. Y'all, do you understand what I'm saying, y'all? The brother, y'all gonna have a paper trail. Because if you're not gonna have a paper trail, and if you haven't put this stuff down, this is what's gonna happen.
You still, Your Honor. I'm trying to address this matter properly. Okay.
And I'm telling you how to address it properly.
But you still
Exactly.
haven't told me what venue you addressing me in.
It's not his job, so refer to the court rules as directed.
I just told you, you didn't like my.
Now, this little nerdy white boy that be up here trying to disclaim us Moors and sovereign people, screw what he talking about, because he ain't no lawyer or no judge. He don't. I don't know if he really know the law, but like King said, uh, Article 6. Okay, not Article 6, but yeah, Article 6 of the Constitution is talking about he has, as a judge, he has to make sure that he understands everything that's going on. But the brother is not articulating the proper things. There's things that you have to do to bring about these things that will trigger. It's called like trigger language. He has to trigger. The brother is not triggering the proper terms to be used where the judge can understand what he's doing. And this is what our problem is as sovereigns when we talk about jurisdiction. So this is why this video that we're playing and the video that we put down in the information we have in this video is important.
My answer. So with that being said, we're not going to go back over this again. You're going to either set the matter for a pretrial date. I'll give you an opportunity to write motions, and you can put whatever you feel that the law is, at the state of the law as you know it, or the state of the law as it is, well, with the court rules and the statutory laws and everything. You can put that in there, and then I will let Ms. Snyder or somebody from the city law department respond, and then I will make a ruling on how I feel who's on the right side of the law or not. Okay?
Your Honor, am I on record?
You are on record.
I'd like to make a matter of record that Your Honor hasn't answered my question properly.
Okay.
I'm not.
Y'all, he's not hearing what the judge is saying. The judge is telling this dude. Do you understand? See, this is what y'all gotta understand. The judge is telling this brother what he needs to do in order to get this done right. And the brother is not understanding this because he's not understanding the law. You got, I know you've been in and out, brother. Go ahead and say something.
Yeah, so a lot of times, we got to understand how to do this. Like, for example, you got to know what your rights are. You have a right, an opportunity to be heard. You have a right to make an oral motion. These are things that you have to address. You don't, if you ain't put the motion in, you could go out the fly and say, Your Honor, I would like to make a record. Could I make an oral motion? And
But you know what? I not one time have I heard him say, I motion to do anything because the sovereigns be like, oh, we can't do motions. We're just going to force our voice on him. We're going to try to talk over him and force ourselves over him instead of motioning, like you said,
right.
an oral motion or a written motion.
Or even a notice. I tell people, you know
Yeah,
how powerful a notice is. You can put the court on notice. I'm putting the court on notice. You don't have to do necessarily a motion in that regards and to understanding the nature, but you can put the court on notice. Notice how you're going to appear, a notice of cause of nature and cause of action, and you can put it on both the prosecutor and the judge. And then you can now, when they don't want to give you those things, now you can start doing the motions. Like I said, you can hit them with the motion, right? Um, under discovery, it can become the form of discovery. You can put it all in a notice, and then you put them in the form of discovery. Then you put it in a motion. Like I like to use a motion of omnibus. I like to put more than one motion in a motion. So I might have 3 motions in one, and then asking for those things. And then I'll be alerting the court on speedy trial violations, all of these due process issues. So it'll be, uh, and then I hit the court with sanctions. So we're talking about, um, we talking about speedy trial. We talking about Brady. We talking about other Sixth Amendment. We talking about due process. So I'm hitting them. I'm collaterally attacking the jurisdiction all at once, and then I'm hitting them with the motion for sanctions and to be heard. Now I raised about 4 or 5 different issues, and they all surrounding due process that the court guaranteed. When the court act like they don't want to deal with that, then I say, okay, Your Honor, I see that you don't want to be in compliance. Either I'm gonna ask you to recuse yourself. I might put in a motion of recusal for not adhering to his constitutional obligation. I might hit him with that, or I might just hit him with, okay, since the court don't want to comply, I'm gonna hit him. I'm gonna file a motion to stay trial, and then I'm going to hit him for a notice of injunction, and then I'm gonna file an injunction with the appealing court to stop all this. I'm gonna take it out of their hands. And then I'm gonna have the appealing court address all my due process issues. Period.
Jay, I'm
Satisfied with Your Honor's answers to my questions. I also feel as though I've been threatened. I feel like I'm under duress right now or coercion. I like that to be a matter of record. And I'll let you do what you got to do, Your Honor.
Okay, so we have a jury trial date already set for 4 of the cases. We'll add these other cases to that jury trial date on May the 7th.
May the 7th?
And these motions, let's give you a motion date before May the 7th. Why don't you give me the motion by April the 26th, your motion will be due. So that's a time where that's April the 26th, 4/26/2024, motions due, and the response to those motions, if you write them, will be on Friday, May the 3rd. The city will respond if they choose to respond. And then we'll set a final pretrial date, on May the 6th. So your next court date will be a day before the jury trial date on May the 6th. And then I'll make a ruling on the motions on that day. I'll have read your motion.
I'm gonna stop it real quick. I ain't gonna lie. The judge is, in my opinion, the judge is being pretty fair in how he's addressing this, because I've seen a lot of judges when they dealing with so-called sovereign citizens or whatnot, that they're really, abrasive and, very intimidating, and kicking them out. And like, let's say 10, 12 years ago, they wouldn't have gotten this far in a lot of cases. You know what I'm saying? I don't know if you have anything to say on that as well.
What I try to tell people is you got to be cordial and you got to know the decorum of the courtroom. So you have to, when the judge, like a lot of times they'll cut you off, you have to ask the court, if you're going to give me an opportunity to be heard and to present my case. That's because you want that for the record. For the record, are you going to give me an opportunity to be heard? I didn't have judges tell me, I'm denying you your right to be heard. Thank you. For the record, let this court make this record that the judge denied me a right to be heard. And on that, I want to move this case probably to a federal court or to an injunction where the court is denying me an opportunity. The court blatantly told me they're going to deny me, and now I can move. So now you can file your 1983s. Now you can file your injunctions, because now the court has deliberately abused his discretion and denied you, for the record, that he's going to deny you to be heard. These are stuff that you have to know, man. People have to know these things because it's too many moving parts. This is why you got the pro se moves. Y'all need to be lining up saying, hey, King El Bay, I want to holler at you about some stuff, and Chief Bandele. We just letting people know based on our experience how to critically think. This is a critical thinking exercise. And when you don't know what to do, this is how you stop all the shenanigans. And I didn't have the court where the appellate court didn't want to answer. They didn't want to deal with the stuff that I dropped in their lap. So the guy was like, hey, I was just like, hey, what's up with the court? What y'all doing? They just quietly just let the case just dissolve. Cause they didn't want to take a bite out of that. Because they knew that it might lead to some type of lawsuit. So they was like,
It might open a can of worms.
Open
the can of worms, man.
Right.
Pandora's box.
So they just allowed the case to just dissipate, and I wasn't gonna complain about it.
Right. I think that's pretty much it. I'm gonna hit it again, but I'm gonna see. I can't remember.
If the city responds, I'll read their response, and then I'll make a ruling on the motion, and we'll see if May 7th that we need that order that jury. All right. You have any further questions, sir?
Yeah, he does. Like where he can find a barber that doesn't specialize in a Cosby on top and Snoop Dogg on the sides.
So you put whatever you need to put in that motion, however you feel the state of the law is. I would like to be able to read what you're talking about, because I don't really understand your position right now. All right.
Okay. And that's the other thing I wanted to talk about, because like the name of the video is called Tells a Living Corpse. So the guy came in there talking about he's not a corpse, and he's a living being, right? And these are all the type of things that we try to do in court. The judge, either he's playing dumb, which I'm gonna tell y'all, judges really are not trained in this. So y'all can stop saying what he know and what he don't know. Y'all can stop that. The judge may not necessarily know what he's talking about. This dude might not even be a judge. He might be a magistrate. They don't know all this tactics that are being used by the alleged sovereign citizen. So when we go in there talking all that stuff, you're talking about stuff that he don't know or that he didn't learn in being a lawyer. So like what Brother King say, when we talking about going in there and hitting them, when we hitting them, we talking about due process, violations. These are trigger language. This is trigger language. When you start saying certain terms, they do know those terms. I mean, there's no way that he doesn't know what due process is, of the due process violation. There's no way that he doesn't know these things. Okay. But if you're going there talking about a corpse and these type of things, I mean, that's not necessarily legal stuff that he's really going to get into. He may not know that. He might have learned about it through people coming in there with the case and presenting that to him, but he's not taught that in law school. Come on. Y'all using terminology and stuff that's not practical or being something that he can communicate with. You can't communicate that with a judge. So that's why the judge is saying, look, I'm giving you an opportunity to present your case, but I'm gonna need y'all to put it in paper.
And he gave him a hearing date, right? And then he said, you gotta schedule trial date. They scheduling for trial. That's why, I like to hit them when I hit the injunctions and I file a motion to stay trial. Why am I saying that? I'm asking the court to stay the trial based on the what? I'm filing an injunction. I'm putting the court on notice that I'm filing an injunction and that I'm transferring this case to the appealing court. Now it's taken from his hands. He don't have no more authority to rule. Now the appealing court got to deal with it. Because I'm telling the injunction is equity. A lot of people don't know. They be talking about it's an equity. It's an equitable relief. It's dealing with fairness. So when I filed an injunction and I start complaining to the appeal court, I'm asking them for equitable relief based on the due process violations that's been occurring. That's identified that everything that I'm identifying in the record. Here's the evidence. They're not doing this. They're required to do this because these are bills of rights. These are rights. These are not privileges. These are rights that they have to follow these things. They can't get around this stuff. So when you hit them like that, they have to acquiesce. That's a part of the requisites. So that's why I tell people you got to know those constitutional reliefs so that when you hit them with these things, I make them things disappear. Now we finna make this disappear real quick. Why? But you have to understand this stuff to the degree that I do, or you're not going to go in there and have the success. Like you said, that is trigger language, and it's called substantive due process. They're violating procedural and substantive rights. These are rights. These are not privileges or benefits. These are rights. And if the court can't determine, ignorance of the law is no excuse. That's why I hit them with everything, with the motion for sanctions, and the motion to dismiss for failure to state a claim. I hit them with all of that. Boom, boom, boom. I come in there and hit them so heavy, they head be spinning. They be looking for the judge. A judge. I'm like, yeah, I know you need some help. And so when the judge start reaching, I say, Your Honor, is you practicing law from the bench? I need to understand what's going on. Because it seems like you speaking for the attorney. And if you're going to do that, would you give me some of that over here, Your Honor? Because I'm objecting to everything you're doing. Please, if you're going to be fair, please, is you showing biasness? And if you're going to do that, now it's time to start recusing yourself, Your Honor. Could I get a judge that's going to treat me fair and impartial with impartiality? These are the things that you have to know. When you've been tested on the battlefield so much and you've been boots on the ground, you can break this stuff apart. You can throw daggers at them. Because all the prosecutor going to do is he going to be shaking, needing help. I seen them. I hit them with that. They be coming there. I'm like, Your Honor, I already put it in. And you can do this at your arraignment. Don't let them trick you in thinking that you got to go, that he can make a plea. Your Honor, he was like, the judge was like, well, sir, this arraignment. I said, I know. I said, do you know the rules, Your Honor? You telling me I can't file no motions? Is that what this court trying to tell me? Well, I'm just asking, Your Honor, is that what you trying to tell me? Based on your years of experience and your knowledge, you telling me I can't file no motions at this time right here? They be looking at me. They don't know what to say. I'm just trying to get you to answer the question. Hey, prosecutor, could you answer this question for me, Mr. Prosecutor? Am I allowed to file anything into the record right now? Y'all got all these records. Y'all want to read off the charges and all of this stuff. You telling me I can't make a record and y'all can make a record? When they be stumped. They be trying to move it forward. Then that's when I just go ahead and hit them with the injunction. Or I hit them with the failure to state a claim. I already got my stuff set up. So when they start trying to move, it's already, they gonna try to tap dance. And I'm gonna object to all of that. We ain't doing nothing. I ain't finna answer. I ain't, because you have a right to remain silent. So you got to remember, once you put that in, and the court don't want to entertain jurisdiction, and they don't want to entertain your motions, and all you got to do is, I'm asking the court, is the court denying me an opportunity to be heard? That is a due process issue. If you move away from due process, you're going to lose.
That's gonna be a show right there. That's a show in itself. Due process, y'all. We gotta get into due process. Y'all gotta understand the due process. So
we heavy hitters. We are heavy hitters. We the pro se modes for real. We the heavy hitters.
Hit us up at indigenousmoors.org if y'all need some assistance. If y'all got some issues like dealing with, traffic, whatever, we'll help you as a pro se. Understand that this is not legal advice. Okay, this is just our opinion. This is just our opinion. All right, so we're not lawyers.
We don't practice no law. This is for education and entertainment purposes only. You can get you a coaching session in the form of a donation. Please come and donate. We're a donation-based institution. If you like to learn more, please donate and subscribe to our channels. And we're going to break this down for y'all. Y'all, we here to help the community and give charity to the people. Y'all want some of this? What we got over here? Come on, contribute, donate, and donate plentiful. Donate, don't be scared. Just go ahead and donate heavy. Hey, we want to donate.
Right. Why? You gotta understand, we going against courts, which got like a lot of money. So if we don't, how are we gonna stand up against them and have the same fight when we don't have the same kind of money? So we donate,
and that was
come on indigenous.moors and donate.
Just
That'll
donate.
help us to fight. That'll help us to help fight for you.
Fight for you.
So if you guys got issues, legal issues, call, hit us up.
Hit us up and
donate. Indigenous Moors, yeah.
And the reason why I say with the donation, that show that we have the back. The people got our back. We'll have the community back, and the community, if they donate, we'll have your back. We coming in swinging. We knocking stuff out the park. I don't argue. If it ain't due process, I'm not arguing. And if you don't understand, I just showed you all the stuff that you had to cover. We talked about all the local rules. We talked about the rules of evidence, rules of superintendent, the rules of civil procedure, the rules of criminal procedure. Then we talked about state constitutions and the federal constitution. These are all these are all the things that you have to cover and know just for a traffic ticket.
Traffic. This ain't even criminal. This ain't even criminal.
This ain't even criminal.
This type of traffic.
Traffic. So you need all of this stuff. A lot of people you need to know this because you got to be able to disqualify. They're standing on qualified immunity, right? Judicial immunity. You got to disqualify their immunity. That open them up for a lawsuit. Because why? These things are called abuses. These are abuses. Anytime the court abuse any process, it's a wrap. Now they're set up for what? A lawsuit. Their immunity has been waived once they abuse any form of abuse. They abuse of discretion, abuse of power, abuse of process, abuse of subpoena powers. All of these different forms of abuses that I ain't even going. I can show you there's a lot of forms of abuses that a lot of y'all ain't raising. They are now this disqualify their immunity. Now it's time to get paid. Pull those bonds. Go down there and pull those municipal bonds. Go down there to the what they call that pull their bonds on I can't think of it. You heard me say it plenty of times.
What you saying?
Where you go pull their bonds, the judge's bonds, where you go down and I said can't think of it. But you can go pull those bonds, right? Now you can file a claim against the insurance company because now you got a record. You got a public record. This is about creating a record and showing that they abuse you. They're abusing. They're not following the law. They're outside of the scopatory provisions of the law, the gambit of their authority. They're acting on their own acquiescence. Now they're liable.
Right.
You guys got to understand this. Right? You guys got to understand this stuff. So you guys got to be able, when we drop this science, so y'all got to donate. This is, we're going to do this show, but y'all got to donate, man, and donate plentiful. The community need us. We need the community. We need to stop these different things. If you're trying to understand your sovereignty and understand your relationship and your status, because people don't know what status really is. Your status means your relationship to persons, places, and things. You understand your relationship? What is your relationship and what do that mean? Under contractual obligations, are you an obligor? Are you the obligee? They talk about creditor and debtor relations. You have to understand what is your status in relationship to these things. We break this stuff down, right? Risk management. I couldn't think about it. That's what it is. You guys got to go to risk management and pull those bonds.
That's what it is.
Risk management.
Dropping these jewels on y'all. We need to wrap it up though, son. We need to wrap it up though. We done been on here a long time, y'all.
No, it's 2 hours.
Yeah. So
y'all
check out the video. Y'all go back and watch the rest of this video. Y'all catching it late? Go watch the video, man. We dropping jewels in this, no doubt. No doubt.
Heavy hitters. This is your boy Keng signing out. Just letting everybody know we some heavy hitters. Y'all want these? Y'all want to learn how to crush jurisdiction, collaterally attack the jurisdiction? Come and holler at me and Chief. This is Batman and Robin. This is we're the Justice League. You hear me? You know,
Yeah,
this the Justice League. Come on in. We're signing out, everybody. Peace and love. You know, go check out, get the book, How to Stop Child Support. Go get all the Chief books. We doing this. We gonna show y'all. We revolutionizing this. What we're doing. You ain't gonna find not too many. If it is, it ain't too many more out there that's dynamic like us. The dynamic duo.
no doubt, man. So this is Chief Bandele El Chief Bandele El signing off. Tutanana.
Peace.
Peace.